In today's video, we're going to be talking about an update in a California lawsuit called Rhode v. Bonta. Now, this is important for all California residents, but it's also important for the rest of the country. It has broader national implications for a number of different reasons, but one of the primary reasons is that this case is going to be decided by Judge Roger T. Benitez. Many of us are very familiar with Judge Benitez, or as we affectionately like to refer to him to as Saint Benitez. So for those of you who don't know, it was Saint Benitez that originally struck down California's ban on standard capacity magazines. That case was called Duncan v. Becerra. It's now turned into Duncan v. Bonta, since Bonta is the new Attorney General here in California. And that case, after going all the way to the Supreme Court, is now back before Judge Benitez as a result of the Bruin decision. And we should be getting a decision in that fairly soon as well. But this case that I want to focus on is Rhode v. Bonta. And if the name Rhode sounds familiar, it is. So Kim Rhode is our Olympic gold medal trap and skeet competitor, right? In fact, I believe, although I'm sure I'll be fact checked on this, but I believe she's the largest medal winning Olympiad in U.S. history. Anyways, Kim Rhode brought a lawsuit against what was effectively Prop 63 in California. There was a proposition that was voted on by the electorate here in California to do a number of different things, but as it relates to this lawsuit, it was also to require that all ammunition sales be done face-to-face, and the individual looking to purchase ammunition had to go through a background check. I'm pausing this video real quick to talk about a secret giveaway that USCCA is doing right now. They're the sponsors of this video. It's very, very cool what they're giving away. You can find out all about it in the description and the links below this video. Definitely enter soon. All right, let's get back to the discussion. Now, this has been unbelievably burdensome to people. Not only has it prevented people from buying ammunition online and shipping it to their home, which is the way the vast majority of people do throughout the United States, now you have to buy ammunition online and send it to an FFL or an ammunition vendor. Once the vendor gets it, then they contact you. You have to go over, and then you have to go through a background check. There are some ways of avoiding that, but it effectively requires you to purchase a firearm. It's just ridiculous, okay? I mean, I'm not going to go through all of the intricacies of this, but what's also fascinating is that there are numerous false positives that end up getting generated by this background check. It's a horrific system. There's a lot of law enforcement officers, interestingly enough, that will go through the background check and they'll be denied because there's a question as to whether or not they're legally allowed to be in possession of ammunition or firearms. So it's created an undue burden along a bunch of plaintiffs, as well as causing ammunition to simply be more expensive. So a lawsuit was brought forth by Kim Rhode, since she uses a lot of ammunition in her training. It made perfectly good sense for her to be the plaintiff in this case. So it was brought before Roger Benitez. And to be quite honest with you, it stalled for a long period of time. And we're not entirely sure what the intercourt machinations have been. However, as of this morning on July 7th, Roger Benitez issued an order. Specifically, he has ordered the plaintiffs and the defendants to appear in his courtroom on Monday, July 17th, not too far away, at 2 p.m. And in this, he is going to be essentially joining a motion for preliminary injunction. This is something that Kim Rhode has asked for. She wants the law enjoined right now while the court case is, ongoing. Well, He's basically said, look, we don't even need to do that. We are going to go ahead and we're going to join the preliminary injunction along with the trial in and of itself. This isn't a factual dispute. This is simply a question as to whether or not this law is unconstitutional. Now, what's interesting is in this order, Judge Benitez kind of gives a list of the things that he is going to be ruling on. I have a sneaking suspicion that the decision might have already been written, but that notwithstanding, he's actually calling out the state and telling them specifically what it is he's looking to see. All right. So we'll go over these individually, but the first thing he wants to see is plaintiffs continuing Article 3 standing. All right, so Article 3 standing, that's a constitutional argument essentially saying that there is in fact a case in controversy, and as a result of that, the plaintiffs have standing to sue. If there is no case in controversy, then the case must be dismissed as being moot. State is more likely than not going to argue that the plaintiffs don't really have standing because they can still get ammunition, at least 80% of the time. Forget the 20% of the time where they're denied for a false positive, but at least 80% of the time they can. And, who cares whether or not it's more burdensome or expensive to get ammunition? There is no real case in controversy. I suspect that Benitez is, in fact, going to find that Miss Rhode does, in fact, have standing. Whether the plaintiff's conduct is covered by the text of the Second Amendment. So this is something that the state has argued, and I mentioned this in a couple of other videos before. The state is now taking the argument that nothing is covered by the Second Amendment. You can have the most restrictive gun control statute in history, right? That is not actually going to implicate the Second Amendment because there's going to be some tiny little nuance, whether the individual is part of the people, as we've seen in previous cases, or whether or not the individual's right to bear arms actually includes the right to bear the type of arms that they want to bear. All right. So there's more likely than not going to be some argument on the part of the state that the Second Amendment doesn't apply to ammunition. I think that's going to be shot down, no pun intended, relatively quickly. Then he calls out something very interesting. He says the applicability of footnote number 9 in New York State Rifle and Pistol Association v. Bruin. So footnote number 9 is the part of the decision that in Bruin where the court essentially opines that you can still require individuals to get CCWs, right? There's nothing inherently wrong with that. Now, I have some issues with this, to be quite candid with you. I mean, when we look at the underlying constitutional test of, looking first at the text and then the history of firearms regulations that they existed in 1791, it would, at least at first blush, appear that there was no type of carriage regulations or licensing that existed during the period of the ratification. And yet the court has kind of carved out this unique area where they say, look, as long as the CCW is issued based on objective criteria, not subjective, not the state deciding whether or not this particular individual should be allowed to exercise this constitutional right. As long as there's some objective criteria, then you can still require CCWs. Now, having said that, they also do give the admonition that if the administrative hurdles to getting the CCW are going to be construed as being overly burdensome, and that's kind of left up to interpretation. Overly burdensome could be, exceedingly long wait times. It could be unbelievably expensive fees. It could be all sorts of different types of hurdles that, bureaucratically that you have to go through. If the plaintiffs can show that these administrative hurdles are overly burdensome, then that will be construed as being unconstitutional or an unconstitutional infringement on somebody's ability to carry a firearm. We haven't seen that lawsuit yet, but I suspect that's going to come fairly quickly. In any event, he asks about footnote number 9, and I suspect that what he's looking to do is have the state as well as Rhode make the argument that this type of regulation is consistent with the Bruin decision. And what's interesting is that Benitez may very well be laying a trap for the state. Because if the state sits there and says, oh, now this is perfectly consistent, we have this regulation, it's totally fine, and it's consistent with Bruin, he can then argue against that and suggest that these background requirements, these, extra times and things like that, create an undue burden on this constitutional right. This can have broader effects. It might not just be relegated exclusively to ammunition. It could then be used as an argument against a lot of different things that are burdening the ability to exercise your Second Amendment rights, from waiting periods to, you name it, all right? So it's interesting that he's specifically calling out for the parties to be prepared to engage in argumentation on footnote number 9. He also wants them to talk about the Dormant Commerce Clause, and many of you have heard that term floating around before, the Dormant Commerce Clause, and I've actually gotten emails from some of the viewers asking exactly what that means. So the federal government, pursuant to the U.S. Constitution, is responsible for regulating commerce among the several states. So if Congress has a law that says this particular type of activity, commercial activity between two states, is going to fall under this form of regulation, that is going to be presumptively lawful. But what happens when a state creates an undue burden to a member of another state being able to sell their products into the first state? I mean, it's not a federal restriction. It's simply that the target state has created barriers that prevent someone from selling their product that happen to live in another jurisdiction. That's what we refer to as the Dormant Commerce Clause. That yes, Congress may not have spoken directly on this particular subject, but silence by Congress should not be seen as an abdication of their jurisdictional control, right? If a state creates an undue burden on commerce, this will be a violation of the Dormant Commerce Clause. Now, the Commerce Clause, as a means of, essentially enforcing civil rights and giving sort of federal jurisdiction, is not generally looked at anymore as being particularly a persuasive argument. It was used a lot, especially immediately following the Civil Rights Act in the 1960s, but it's sort of somewhat fallen outside of favor. This might be an argument to reinvigorate the concept of the Dormant Commerce Clause. After all, we're talking about two separate things. We are, in fact, talking about individual conduct as it relates to the Second Amendment, but we're also talking about, stuff. In order to exercise your Second Amendment rights, you have to acquire firearms or knives or baseball bats or whatever it is, whatever arm it is we're actually talking about. And even if you're going to engage in the manufacturing of home-built firearms, you still need to get the raw materials in order to manufacture a home-built firearm. So there is going to be a nexus to interstate commerce, and whether or not Congress has specifically regulated this activity, a state regulation that essentially encumbers someone else from being able to sell their product into another state is probably going to be seen as a violation of the Dormant Commerce Clause. Preemption of 18 USC 926A. This one, I'll be quite candid with you. I'm not entirely sure I understand where where Benitez is going with on this, but this is essentially the ability to be able to transport firearms across state lines, along with ammunition, consistent with the laws of the original state in which you reside. So if I'm traveling from California to Nevada, I'm able to bring my firearm with me. Now, I do have to ensure that the firearm is unloaded in a locked container outside of my control. Well, actually in Nevada, that's incorrect. But if I was a Nevada resident coming into California, this federal law would preempt state laws that say, you can't have a gun in California or something along those lines. Since I was legally allowed to buy it in Nevada, I can bring it into California. However, this federal law, which predates Bruin, would suggest that I cannot carry the firearm across state lines without having a concealed weapons permit in California. Like I said, I'm not entirely sure why he specifically called on that, but we'll certainly see. And then whether judicial deference is owed to laws produced by ballot measure, specifically Prop 63. This is also quite interesting. So California has a proposition system. One of the reasons for this is that, the California legislature had become such a lockstep political party mechanism that to a large extent, they had been engaging in conduct that was contrary to a lot of voters' desires here in the Golden State. So we created a proposition system. This would allow essentially a statewide plebiscite. If someone could gather enough signatures, then the entire electorate of California could vote on a proposition. And if the proposition succeeds, then the California legislature has to adopt it. There's some argument to be made that this is contrary to what our framers were looking for. There's a reason why we created legislatures and the need for political bargaining to be taking place between different elected representatives, that this essentially comes outside that scope. That notwithstanding, a law is a law. And the question then becomes whether a law was crafted through the initiative process and by the people of California voting on it, or whether the law was crafted by a legislature. Is there a greater degree of weight that should be attributed to one versus the other? Now, ultimately speaking, I think this becomes somewhat of how many angels can fit on the head of a pin kind of an argument, because whether or not the law violates the Constitution is really the ultimate question. Whether or not it was made by people in the electorate or whether it was made by the legislative process, I think becomes utterly irrelevant. But nonetheless, St. Benitez has asked for the parties to opine on this. Now, since he is consolidating everything, I do suspect we should be getting a ruling on this fairly quickly. We've got, what did I tell you guys? The 17th, I believe. Yeah. Monday, July 17th, the arguments are going to be heard in his courtroom. I wouldn't be surprised if by the end of July or early August, we get a ruling on this. This also may free up some of the logjam on some of the other cases that Benitez is still sitting on. And again, it's unclear as to why he's still sitting on these cases. But we've got Miller v. Bonta, which is a challenge to California's assault weapons restrictions. We've got Duncan v. Bonta back down now after having been sent back from the Supreme Court to now be adjudicated based on the Bruin test. So we still have stuff that he's going to be ruling on, and we've been waiting for a decision. It may very well be that all of these decisions come out simultaneously. We'll have to wait and see. As always, if you would like to contact me, please do so. My email is steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.